Ever feel overwhelmed by all those consent pop-ups asking to use your data? You're not alone, and India's new data protection law might make this problem even worse. Under India's Digital Personal Data Protection Act, or the DPDPA, and the Draft Digital Personal Data Protection Rules, or the DPDP rules, businesses in India must get your informed consent before they collect and process your data. Under Rule 3 of the DPDP rules, every consent notice shown to a user must give them a fair account of what data is being collected, why that particular data is needed, how users can exercise rights like withdrawing consent, and how to complain to the Data Protection Board of India if needed. But here's the catch. No one really knows what the phrase fair account means. So businesses are likely to create massive, exhaustive consent notices covering absolutely everything just to ensure that they're compliant with the law. The result? Consent fatigue. People stop reading consent notices and simply click I agree without thinking. Consent essentially becomes a meaningless box-ticking exercise under this framework. This isn't just speculation. Laws like the EU's GDPR are emblematic of this problem. Researchers estimate that the GDPR's complex consent notice requirements have resulted in privacy policies and consent notices that would take an ordinary user 76 workdays to go through. Another problem stems from the infeasibility of displaying consent notices in scheduled languages. Section 5 Clause 3 of the DPDPA states that businesses must provide consent notices in English or in any of the other 22 languages listed in the 8th schedule of the Constitution. But to begin with, this may be onerous for small and medium-sized organizations who typically lack the resources needed to translate consent notices into all 22 listed languages. Our 2023 study found that while 84% of businesses already present consent notices, 94% would need to make significant technical changes to their infrastructure to comply with this language requirement. Why? First, many legal terms simply don't have direct translations in languages like Bodo or Dogri, for example. How would you accurately explain something like a data processing right when the words for it don't exist in another language? Second, businesses often operate in regions where none of the 22 scheduled languages are widely spoken. Some provide notices in languages like Rajasthani users actually speak, but these aren't officially recognized under the 8th schedule, so businesses would be forced to offer notices in languages their users don't understand, while excluding the ones that they do. To solve some of the problems with consent, the DPDPA introduces something called a consent manager. A consent manager is an intermediary registered with the Data Protection Board that helps users give, manage, and review consent across different platforms. To register, consent managers need to meet a few requirements, such as having a net worth of at least 2 crore rupees and having no conflicts of interest with any business that they work with. The concept of a consent manager isn't entirely new. India already has similar systems in financial services through the account aggregator framework launched in 2021 and in healthcare through the Ayushman Bharat Digital Mission. But there are serious concerns about whether consent managers can actually work as intended. The first problem stems from conflict of interest obligations. If consent managers are supposed to help users, but it's unlikely that users will pay for their services, where is their revenue going to come from? Most likely from businesses that use them. And that creates exactly the conflict of interest that the rules try to prevent. It's also not clear what the incentive for the uptake of a consent manager framework is. If we think about it from the point of view of a business, a consent manager could make it easier for a rival to access its customers' data. This means that there's very little incentive for a business to participate in a consent manager framework. Even worse, consent managers may sometimes threaten or file complaints against businesses that refuse to work with them, simply to force integration. A third problem stems from India's lack of digital literacy. Consent managers usually rely on privacy self-management, which is the idea that users can protect their privacy by making informed choices about their data. But in a country where a significant proportion of the population lacks digital literacy, can this really work? India's DPDPA was designed to be streamlined and straightforward, a law that would be easy to implement and beneficial for everyone. But its complex consent mechanisms end up creating exactly the opposite result. Businesses face unclear standards and compliance burdens, while users get overwhelmed and tune out. In the end, nobody's privacy is actually better protected.
This is the Esya Center. If you found this video useful, please like it and share it. You can also follow our LinkedIn page for more explainers and other updates.